Leslie are out.
That-
Clerk should be up in just a minute to check it.
Rebuttal reserve, that only goes for the appellant, is that correct? Or can the appellee also reserve that?
Is there a possibility?
There is.
Okay, then I will check with the panel. Generally, they will allow some rebuttal in that context. That probably are.
Well, I don't think it would be long. So.
Usually that works out well with the park. Any other questions? We can plan for serving. And the panel is open to serve.
Thank you.
And you will have to contain it within 15 minutes.
That'll be fine.
Questions and concerns? Will you file on the internet in just a minute?
All rise. First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon. Welcome to the First District Court of Appeal. We have one case on our docket this afternoon. That's Florida First Financial Services versus Angel Randolph and Donald Edwards, 661. And then the cross appeal arising from that same case. Are counsel ready to proceed on the case? Go ahead and proceed. And before we get started, though, Ms. Rolfe, would you like to reserve some time for rebuttal as well as for responding to any argument on the cross appeal?
Yes, sir. I would like to reserve this
5
5 minutes.
minutes? So noted. Thank you. You're welcome to come up to the lectern and proceed when you're ready.
Thank you. Good afternoon. May it please the court. My name is Amanda Rolfe, and I am representing the appellant, Florida First Financial Services. We are here today seeking reversal of the trial court's order granting entitlement to attorney's fees and a subsequent monetary award pursuant to 571057, because the contract contained a choice of law provision that provided for Alabama law, and Alabama does not have a code that makes attorney fee provisions in contracts reciprocal like Florida does. The trial court incorrectly found that, and I'm going to use abbreviation FFFS, had waived the choice of law provision because it did not plead Alabama law in the pleadings, and that the parties argued Florida law on the underlying issue that was litigated before the court. However, Randolph was on notice that the contract terms, of the contract terms.
Well, they were on notice, but why was the trial judge wrong on the arguing, Florida law? I've got plaintiff's response in opposition to defendant's motion for summary judgment that cites our cases, cites Florida Supreme Court, cites Florida statutes, says Florida law is clear under Florida law, and so on. So you use the sword of Florida law. Why do you get to use Alabama law on something that would harm your client?
Sure. The underlying issue was compliance with Florida statute. Although the contract was entered into in Alabama and provided for Alabama law, the defendant, Randolph, resided in Florida. So therefore, the notice that was the underlying issue in dispute in the matter had to comply with Florida law. So that is why Florida law was argued throughout the underlying litigation and the summary judgment, because it was.
Is notice different than whether the disposition of the collateral was commercially reasonable? Is that a separate issue?
That's the issue that I'm referring to.
Well, is that cause of action on the contract at all, or is it?
It's not, and that was going to be my next point, was that because that argument was based on, or that litigation was based on compliance of the Florida statute with regards to whether or not that notice included the current creditor, which the court found that it did not, and it did not comply, and so that's why summary judgment was granted in defendant's favor. However, that was strictly based on statutory compliance and had nothing to do with the contract itself and the fact that the plaintiff had sued on the contract to collect the deficiency balance.
At some point, the defendants below, the appellees here, stated that had you invoked Alabama law, potentially the Alabama statute of limitations would have precluded the action that you brought. What's your response to that?
The Alabama statute of limitations on a note of this nature is 6 years, so it would not have.
Would not have, so that's not an issue then.
Right, and the other argument I believe that he made as to the statute of limitations was his counterclaim, and that I filed a motion to dismiss his counterclaim and alleged Florida statute of limitations. Again, same argument as before, that counterclaim was based on a Florida statutory provision that he filed the counterclaim against my client, which we sought to dismiss because my client cannot be held responsible under Florida statute, and then also of the statute of limitations on statutory liability.
Am I correct, there was never a request to take judicial notice under Alabama law, and if so, is that a problem for your client?
It was never requested to take judicial notice. I don't think that it should be a problem because the contract was signed by the parties. It was attached to the complaint. So both defendants and had the opportunity to reread the contract that they had signed. And in addition to that, the motion for attorney's fees relied on the attorney fee provision terms in the contract. So the defendant or appellee used the contract as well and is charged with knowing the terms of the contract.
If, turning to kind of the second issue, if we found that 57-105-7 appropriately applies here, and we disagree with you on your issue on the Alabama choice of law, doesn't your argument then on the limitation of the fees or the way that the 15% is structured basically write out that the reciprocity that's in Florida law? I mean, basically what I'm trying to say is doesn't that allow a clever, well-represented creditor to eliminate the reciprocal fee arrangement in 57-105-7?
No, because the contract is written under Alabama law, and that is the law in Alabama. And I believe I cited that in the brief, that under Alabama law, as long as the default amount, I believe, is above $300, then the most attorney fees that can be awarded are 15% of the amount of owed at default. So the contract was written based on Alabama law, so that's why the attorney fee provision is the way that it is.
Well, my question, though, was based on the presumption that we don't think, assuming we don't think that Alabama law was properly invoked, why should we use that 15% limitation then?
Well, the statute 57-105-7 allows the reciprocity of the attorney fee provision, and but the reciprocity is still limited to the terms of the contract.
And I mean, you're right in saying reciprocity as far as the case law. There's a lot of cases that say it's a reciprocal provision, but the true text of it says the court may allow reasonable attorney's fees, or let me be specific, may also allow reasonable attorney's fees. I don't know if that also has some distinction there. Maybe it does. But is reasonable attorney's fees means just the attorney's fees permitted under the contract, or is reasonable attorney's fees mean attorney's fees under Roe and Quanstrom and all the other Florida case law on what's a reasonable attorney's fee?
Well, I believe it would be a reasonable attorney fee according to the contract. So if the terms of the contract limit the recovery to 15% of the amount of default, regardless of whether it's Alabama law or Florida law, those are the terms of the contract. And I don't read 57-105-7 to allow the court to be able to rewrite the terms of the contract and award more than what the plaintiff would have been able to receive had the plaintiff
Well, the
prevailed.
problem is that the statute doesn't, I think that's kind of what Judge Bowbury was getting at, it doesn't limit recovery to the contract under the, for lack of a better word, the reciprocity provision, excuse me, of subsection 7. So I don't understand why reasonable isn't just what we would otherwise consider reasonable when it doesn't make any reference to the contract in that provision.
Because the parties have agreed to the terms of that contract when it was entered into. So the parties agreed to that limit of 15%.
I mean, isn't the whole purpose of the statute that it is kind of extra contractual? In other words, the contract doesn't say anything about the appellees in this case recovering any attorney's fees, so it's got to be extra contractual.
Well, and most of them don't. So that was the purpose of 57-105-7, is to take those unilateral attorney fee provisions and make them reciprocal, so that if the defendant was the prevailing party and the provision only allowed for the plaintiff to recover, then the defendant would be able to use that statute to recover their attorney's fees. And most attorney's fees provisions in contract don't have a limit on them, and that is why I believe he stated in his brief that he couldn't find any cases that set forth a limit on the attorney's fees because if the contract is written in Florida, most of the time there's not a limit on the attorney's fees. But as I stated, this is an Alabama contract and it complies with Alabama code, and so they had to use those terms in the contract.
And we'll reserve the rest of your time then. Thank you. And Mr. Abrams, you have the cross appeal, so would you like to reserve any time for rebuttal on your cross appeal?
Yes, Your Honor, if I could just have 3 minutes.
3 minutes? Okay, we'll have 3 minutes on the cross appeal. Thank you.
Yes,
Go
Your
ahead and
Honor.
proceed.
Your Honor, may it please the court, my name is David Abrams, and I represent Angel Randolph and Donald Edwards in this appeal. And I believe the primary issue in this appeal is really whether or not the law allows a party to argue the merits of a case using Florida law, but then invoke a contractual choice of law provision after the merits have been decided to defend against an attorney fee claim. And our argument is that it does not, and that is something that has to be pled and proven during the merits of the case. And this case, the Florida law that was pled in this case wasn't just about the application of Article 9. There were pleadings. If you look at the record, the memorandum that was filed seeking to dismiss the counterclaim, it's at 200 to 205. There were argues of substantive Florida law regarding the liability of assignees and holders in due course of the retail installment contract. So we were certainly going beyond just the notice formalities in this case.
Counsel, well, go ahead.
And then the next issue, of course, is how we interpret 571057, but I think maybe you had a question on the first point.
Go ahead.
Okay. All right. So 57105, subparagraph 7, is a very straightforward statute. And we know from the Gardner case that this court decided that we look, when we're doing statutory interpretation, we look to the plain and ordinary meaning of the words of the statute. And in this case, it's very straightforward. There's really kind of a predicate, which is where a contract has a provision allowing attorney's fees to a party when they take action to enforce it. That's the predicate which was met in this case. There's a provision allows attorney's fees. And then if the other party prevails in the action, they're allowed to recover reasonable attorney's fees. And there are a number of opinions that talk about it being a reciprocal provision, or I believe Judge Hinkle wrote about it being making a unilateral provision, a bilateral provision. But none of those words actually appear in the statute. And I think that the straightforward statutory interpretation of this is that the attorney's fees to be awarded are reasonable. And reasonable under Florida law means that you follow the Quantum and Roe factors.
Well, counsel, I don't see appellant's argument as arguing that under subsection 7 that you would not be entitled to attorney fees. My understanding of their argument is that the choice of law provision in the contract kind of overrides the statute, so it doesn't apply anyway. And I've seen some cases that make that suggestion. The first one that occurs to me is cited in the appellant's brief is Giles,
Right.
From this court from last year. How is Giles different from this case?
Well, all I know of
Motion
Giles is
Giles
what I've read in the decision. I did read the Giles decision. And in the Giles decision, the court was not considering a case where the choice of law provision had been waived. I don't know the procedural history of that case or what happened.
Well, what do you make of the last sentence of the opinion? It says, "We likewise affirm on the waiver issue."
I'm sorry, I couldn't hear you.
The last sentence
Yes, sir.
of the opinion before the concurring opinion written by Judge Bilbrey was, "We likewise affirm on the waiver issue." That suggests to me, in any event, that just a suggestion that the same argument was made that the plaintiff had waived the choice of law provision, presumably by not arguing South Dakota law.
Well, I think that if that's the rule, it creates a very unlevel playing field, because it doesn't make sense to me that we decide the merits of the case using Florida law, and then someone keeps a choice of law provision that they have never enforced until they want to defend against their liability for attorney's fees. It looks like at that point, you're kind of picking and choosing your law, which I think once you argue Florida law in a case and you say Florida law governs this case, you've kind of picked your solution. I think it's very analogous to, say, an arbitration matter where many contracts have arbitration provisions in them. But if you file a lawsuit and you litigate that case and you conduct discovery, you can't then go raise the arbitration provision. You've waived it at that
Well,
point.
do we need to get into more, though, about the substance of the case and why Florida law was invoked? So say it was something like the service of process. The service of process violated Florida law, but there's still an Alabama choice of law provision in the contract. I think something like that, arguing that I wasn't properly served under Florida law wouldn't mean that, the Alabama choice of law goes away. How is it such that the arguments made by the appellant below, invoked Florida law to the extent that they're basically stopped to argue that Alabama law should apply to anything in the contract?
Well, Florida law or Alabama law was never mentioned in this case until after final summary judgment. And the multitude of issues that were argued at the trial court in this case, again, assignee liability, Article 9 compliance, the statutes of limitation, all of those issues, which are substantive issues of law, they're not merely procedural, such as a service of process issue. These are the substantive matters of Florida law. Once I think you've chosen to do that, and you have essentially waived the Florida law, and I'm saying you've waived the right to bring to invoke the choice of law provision, and that's consistent with what other courts have held. We certainly saw the two federal courts decisions that we cited in our brief, that the Mendez case, and then there's another federal case. Mendez, I'm sorry, Your Honor. Mendez was certainly, it was a trial court decision of the federal court that looked at Florida law, and just like our present case, it cited that both parties had relied on Florida law in their summary judgment briefs and in the instant supplemental briefs. Therefore, the court will apply Florida law. And even today, we're arguing Florida law.
Are there any of those other legal issues that were addressed prior to the attorney's fee issue where Alabama law was materially different from Florida law, other than what we've already addressed, the statute of limitations?
No, we never really addressed that. It was always under Florida law. The issue of Alabama law really didn't come up until
Well, does it matter then to your position that there's no material difference between Florida and Alabama law on the issues that were being discussed, and not until there was a material issue did appellants raise it?
Well, Your Honor, we didn't examine Alabama law because it wasn't raised. And I honestly can't tell you that I know there is or is not differences in Florida versus Alabama law, because those issues were not briefed at the trial court level. They weren't raised. So there was never an examination undertaken of that. Had we been put on notice, and certainly we would have delved into the intricacies of Alabama law. But it just was never an issue. Like I said, nobody spoke of Alabama law until after summary judgment. There was no attempt to impose it.
As far as the 15% issue, wouldn't an award to your clients of 15% of the amount at issue be closer to the contract than awarding all of the fees that you understandably incurred in representing them?
No, the way the contract is written, it's 15% of the balance due. And so when when I prevailed in arguing that there was no balance due, then I think that negated the ability to recover attorney's fees if you're going to strictly adhere to that provision that we measure the amount of reasonable attorney's fees based upon the balance that is due. Again, Florida doesn't use that standard. Florida uses the Roe and the Courtroom factors. That would be an Alabama law issue. As my learned colleague has pointed out, there is an Alabama statute regarding that. And so it is true that deficiencies are treated differently in Alabama. But again, we never got into that in the case.
On your cross appeal, the fees, you had put on evidence of $350, but then the judge, for whatever reason, awarded $250 an hour.
Right.
Am I correct that there was no evidence to substantiate that award of $250 an hour?
That's correct. There was no opposing expert. There was no argument against it. The argument at that hearing from opposing counsel was really you don't have authority to impose fees, but it didn't go to the amount or the multiplier. It was strictly there were two expert witnesses that we brought who gave testimony to the court. The court made the findings that $350 per hour was appropriate and that a 2.5 multiplier was appropriate. And then at the end of the order, without telling us why, it just reduced the hourly rate by $100 an hour and the risk multiplier down to a 1.5. And it's an inconsistent order in terms of what the court found versus what the court actually awarded.
Can I go back, and I know I'm jumping around, I apologize, but I just noticed something that I meant to ask on the direct appeal. The language in this Florida hurricane protection case and that's been cited with approval by the Florida Supreme Court in the Levy case from last year, 57105.7, Florida Hurricane Protection said 57105.7 is designed to even the playing field, not expand it beyond the terms of the agreement. What does that mean to you then?
Well, I think, again, it's really an issue of who decides what the law is, right? And in terms of the legislature wrote this law saying reasonable attorney's fees. And I think the courts have often, because most attorney fee provisions are straight up attorney fee provisions. In other words, if we bring this action to enforce the debt, we recover attorney's fees. So in most cases, it makes a lot of sense to talk about 57105 subparagraph 7 as a reciprocal attorney fee agreement. But when you follow the words of the text, that's not what the text says. The text says reasonable fees.
Yeah, I'll ask a quick follow-up on that. So the 57105.7, the whole thing is in the context of a contract provision that permits attorney's fees. And it reads that in the event there is such a contract provision, that the court may also allow reasonable attorney's fees to the other party. And so why shouldn't we read reasonable attorney's fees in that context as reaching back to the contract to set and determine what is reasonable?
Well, because I think Florida has a standard for what's reasonable, and that's Courtroom and Roe. And it's a very well-established standard. And I think to alter that would be to really alter what the statute says. I think we have to apply and interpret the statutes according to the plain meaning of the words in the statute. And Florida has a well-established definition of what reasonable attorney's fees. If the legislature had wanted to make it a bilateral provision or make it a reciprocal provision, they could have used that language, but they didn't. They said reasonable attorney's fees, and they didn't qualify it by what the other side could recover. There's no qualifier there. So I think if to be true to the text of the statute, it has to be interpreted as reasonable attorney fees.
Thank you. And I see we've eaten into your rebuttal time here, so why don't we reserve the balance of your time and give you 2 minutes more, and we'll do the same
Thank you, Your Honor.
for Mrs. Rolfe also on her argument.
All right, thank you. Just to reiterate a couple of points, the underlying case was based on an argument on statutory compliance, and that does not equate to a waiver of a choice of law provision, because the letter had to comply with Florida statute because the defendant lived in Florida. Expounding on that, it was based on UCC, which is the Uniform Commercial Code, and as you know, is the same in most states. Each state may add their own little twist to it, but in general, it is the same. However, since the defendant was residing in Florida, the letter had to comply with Florida law. The counterclaim, again, was based on Florida law. The defendant filed a counterclaim against the plaintiff to hold the plaintiff personally liable for the violation of the Florida statute. So that whole counterclaim was based on Florida law, so the response had to be based in Florida law as well. It had nothing to do with the contract or the terms of the contract, as did the underlying litigation. It had nothing to do with the terms of the contract at that point. It was all based on Florida statute. 57105, giving it the plain and ordinary meaning, yes, it does allow for attorney fees to the other side, but it does not grant the court the authority to rewrite the terms of the contract. We cited B&H Construction and Supply Company that says that the right to contractual attorney's fees is limited by the terms of the provision and should be strictly construed. The court does not have authority to rewrite the terms of the contract that the parties freely entered into together.
Well, I mean, 571057 does rewrite the contract, though. I mean, if I had a unilateral contract in Florida that said if I win, I get fees, if you win, you don't get fees, 571057 rewrites that, right? So why, in rewriting that, why can't the legislature, instead of saying the same amount of fees as Party A would have received, just say reasonable fees, and we all know what reasonable fees are?
Because the purpose behind that statutory provision was to make a one-sided, unilateral attorney fee provision bilateral so that the other party could use it. It doesn't, in the statutory construction of that statute, it doesn't give the court the authority to change the terms of the contract that the parties agreed to. And, you know, as we've discussed, most of the time, there is no limit on attorney's fees. It just says that if we have to hire an attorney to represent us, then you're going to be responsible for the attorney's fees. This contract is different because it was written under Alabama law.
Did you want to say anything in response to the cross appeal on the, if we were to agree as far as the court awarding fees and awarding the full amount of reasonable fees under 571057? Did you have any response either to the hourly rate or the multiplier?
Yes, we did not oppose the hourly rate at the hearing because the plaintiff appellant's position was that the attorney's fees should not have been awarded in the first place, and so did not want to continue with that argument and expend those costs to have the attorney fee experts and everything when our argument was that there was no attorney's fees because Alabama law did not provide for them. And at that point in time, the court did go through the factors of Quanstrom, and he cited Roe, and those cases still do not they are not based on the same type of contractual attorney's fee provision that we're dealing with in this case. So we can go through the factors of those, but it doesn't apply in this case because the attorney fees shouldn't be awarded anyway. And we have the Supreme Court cases that we've cited, the Mazzoni Farms, saying that the choice of law provisions do not require, that the courts have enforced choice of law provisions without requiring the parties to brief the law of the chosen forum. And then Southeast Floating Docks, that says that Florida law will apply in instances where the parties have agreed to be governed by the substantive law of another jurisdiction. And the only way to get past that is to show that there is a strong public policy that overrides.
Well, counsel, requiring you to brief Alabama law and explain how it's different strikes me as at least somewhat different as notice that you're intending to rely on Alabama law. So does that necessarily apply to the argument that the appellee has made in this case?
Well, the Alabama law did not become an issue until the defendant and the appellee moved for attorney's fees. And then at that point in time is when Alabama law was briefed and it was set forth, the code was set forth in the response to the motion for attorney's fees. The only, I guess I have a few seconds left. The last thing I would like to say is that the trial court order should be reversed because it defies the Supreme Court cases that we have cited in our appeal and that I just went over, holding that choice of law provisions are given or trump the 57105 7 provision of the Florida statutes.
Thank you, counsel. And then we have rebuttal on the cross appeal.
Thank you. When the trial court in this case did a bifurcated attorney fee hearing, right? We had one section that was on the issue of entitlement, and both parties were heard, and the trial court issued an order, and that order became the law of the case. And when we went to the hearing, if I were on the other side of that, I don't think that I could not make an argument with the idea that I could preserve whatever I didn't like about that argument or disagree with it in terms of the finding of the amount based on the fact that I didn't agree with the prior order. I think that if opposing counsel thinks that there are too large a fee was awarded because the quantum or row factors weren't followed properly, that argument needed to be made at the trial court level. Again, the issue of the appeal is really very narrow. It is the inconsistency in the trial court order, where the trial court made the findings of fact based upon the testimony of the witnesses that came, that $350 an hour was a reasonable rate, and that a 2.5 risk multiplier was appropriate. Where the trial court judge erred in that section was simply, if the trial court judge wanted to reduce the amount, the trial court judge, according to the case law, needed to state the reason why. It just can't be done arbitrarily. And that's why we feel like it should be reversed. And thank you.
Thank you. Thank you both, counsel. We appreciate your argument, and with no further business to come before the court, we're adjourned. Thank you.
All rise. Carry on.